Good morning, just everyone, and thanks, Jonah, for the introduction. There's the slides, great. As Sean has just said, I've been asked to talk to you today on the topic of delays in documentation, picking up from the recent ICAS report issued in respect of insolvency monitoring findings from visits in 2021 and 22. Whilst delays in documentation may not seem to be the most exciting of topics, and I am aware that I'm the last session of the conference, it's nonetheless a very important area, as the risks of not getting it right can be significant. The areas I propose to cover today are statutory filings and deadlines, case progression issues, AML deficiencies and delays. Stephen talked about AML yesterday, so I don't propose to say too much on this. Evidence to support work done, documentation errors, ethical considerations of code of ethics procedures, and last but no means least, pension checks. The objective of this session is to offer some reminders and suggestions as to how you can avoid the above issues being identified in your future reviews, and that if nothing else, you come away with an increased awareness that if it isn't documented, it doesn't happen, especially from a regulator's viewpoint. I'm going to start with a look at statutory filings and deadlines. Issues in relation to statutory filings and deadlines were the most common finding in ICAS monitoring visits in 2021 and 2022. In corporate appointments, it can be relatively easy to make an error in notice days under the now not so new 2018 rules, and 2016 for those of you following us from south of the border. Whilst it may appear that not giving sufficient days notice is not a big deal, it can invalidate the process you're trying to effect, and/or remedial steps may need to be taken by way of rerunning the process, or even the cost and time of a court application, the cost of both of which can't be recovered from the case. In addition to getting the notice periods correct, there have been a number of disciplinary outcomes published recently across the RPBs, which have included delays in or failure to comply with statutory filing requirements. It's important that these statutory deadlines are adhered to and that the controls in place are complied with, i.e. diary lines and prompts and the review of late diary lines. Let's go back to notice periods in corporate appointment and have a quick refresher as to the minimum timescales for issuing notices by post, email and website delivery. The Insolvency Scotland CVA and Administration Rules 2018 and the Insolvency Scotland Receivership and Winding Up Rules 2018 and the Insolvency Rules 2016 all follow the same basis. Remember, the number of days is clear days. For England and Wales, this is defined in Rule 2.8 of the Civil Procedure Rules and not in the Insolvency Rules themselves. The day the period begins and the day of the event are not included. For delivery of first class is treated as delivered on the second business day after the day is posted, and second class is treated as delivered on the fourth business day after the day is posted. Electronic delivery email, assuming you've got actual or deemed consent for this method of delivery, is treated as delivered at 9 AM on the next business day after it was sent. Website delivery is treated as deemed to have been delivered when it's first made available on the website. Let's walk through an example of what the different deliveries might look like in practice. If a notice was sent by first class post on the 5th of June, then the day of deemed delivery in accordance with the rules would be the 7th of June. This deemed delivery date would be the same date if the notice was sent by email on the 6th of June or posted to the website on the 7th of June. Following the rules, the first day of the notice period would be the day after it was deemed delivered, so 8th of June. Assuming the process required 14 days notice based on a deemed delivery date of the 7th of June, the 14th day of the notice period would be the 21st of June, which means the first available decision date would be the 22nd of June. Remember, there's a requirement to take into account public holidays and postal strikes if known, but there's no requirement to hold the decision date on the first available date. It might be prudent to consider allowing a safety net of a day or two to be added to be on the safe side. Case progression issues is another matter that's close to the heart of the regulators and was the third most frequent finding in recent ICAS monitoring visits, particularly in relation to public interest and the concern that harm may be done to creditors by virtue of cases not being progressed in a timely manner. There are a number of things to think about in respect to case progression. Is there appropriate oversight and control of cases? Are regular case reviews carried out by the IP and/or a senior member of the team? Is the IP familiar with the case? How are outstanding issues monitored or tracked? Diary lines could be added to the software diary as a reminder. A spreadsheet could be maintained for each case, which lists outstanding matters and tracks their progress to conclusion. Either or both of these approaches could also be reviewed as part of each regular case review. What processes are in place for case handovers? It's not unusual for appointments to move between case team members and/or for team members to move on from the firm, or indeed even IPs to move firms. It's important to have a proper handover process for these circumstances, so that the new case team do not have to spend extra time familiarising themselves with the details of the appointment, again time which shouldn't be charged to the case, and it mitigates the risk of issues being overlooked. Does the case have challenging issues? With the best will in the world, sometimes a case falls into the hard-to-do pile. It's obviously important to try not to let this happen. If for some reason this is a risk or has already happened and been identified, the way forward may be to seek advice from another party. The issue may be resolved or progressed by discussing the matter internally within your firm, or professional external advice may be the way forward. Doing nothing risks potential harm to creditors and the wrath of the regulator. One of the main reasons for the regulator's concern over lack of case progression, apart from it indicating a possible lack of control, is that delays in paying dividends prejudices creditors. Generally speaking, legislation requires the payment of dividend at the earliest opportunity, obviously providing for future costs. In the case of corporate appointments, distributions should be considered in respect of court accounting periods, and every endeavour made to comply with this. If you're unable to pay a dividend at the end of accounting period, the reasons why should be documented. Dividends obviously require funds, so it's important to ensure funds are gathered as soon as possible. Some examples are to remember the obvious: write to the bank on appointment and ensure any funds are gathered at the earliest opportunity. After a transaction, ensure funds held by an agent or lawyer are received promptly. And pursue and gather book debts as soon as possible. It's always more difficult to gather book debts the longer they are unrecovered. Is there a programme for case closure when all matters are concluded? How are your cases controlled when all matters are concluded? Is there a closure diary or process in place for your staff to follow? Who reviews the progress to closure? These are just some of the matters which need to be considered in relation to case progression. There will be others, but the important thing is to keep cases moving. If for some reason the steps you're taking are not resulting in the case progressing, then remember to document what the difficulty is and what you have done or not done. This is good practice and serves as self-protection should you be queried on your strategy at a later date. I've noticed the possible risks for lack of case progression on the slide, but to be honest, they probably apply to a number of the issues I've talked about or will be talking about today. Possible risks are monetary loss to an estate if an asset isn't realised at the earliest opportunity and the potential for value to be diminished. There may be a requirement for an IP to make good any loss to the estate. Creditors may be prejudiced by delays in the payment of a dividend, and there is a risk of regulatory action and the possibility of reputational damage. Stephen covered AML in some detail yesterday, but I thought it would do no harm just to add in a few points in relation to the topic of delays in documentation. My reminders would be the following. Always save full copies of your AML documentation and approval process to your filing system. There are several reasons for saying this. If you rely on an electronic system and your appointments stay open for a number of years, it's not impossible that the documents aren't saved to the file at the time it may become difficult to locate them later if you've transferred to a new system. For example, the IP may move firms and may or may not take appointments with them. If appointments move with an IP and there isn't a copy saved in the file, it may be more difficult to retrieve a copy at a later date. Your regulator requires you to be able to demonstrate to it that you've complied with the requirements of the AML legislation, and if you don't have a record of your processes and actions available to show them, it's very difficult to prove your compliance. And certainly as an ex-regulator, that used to be one that we came across fairly frequently. KYC extensions. The money laundering regulations require you to complete your KYC prior to engaging with your client or taking an appointment. However, in some circumstances, an extension can be requested from your MLRO for a period of up to 5 days. This extension should be formally requested and a copy of the formal authorisation saved to the case file. Any further extension should also be formally documented. If KYC is unable to be obtained, you need to consider why you've been able to complete it and take appropriate steps. I've provided a link at the end of the presentation to ICAS's General Practice Manual, which is a selection of AML checklists, which may be a useful resource for you, to those of you who are members. It's a requirement of SIP1, we're going to talk about evidence to support work done now. It's a requirement of SIP1 that IP should ensure that their acts, dealings and decision-making processes are transparent, understandable and readily identifiable. Evidence their compliance with SIPs and should therefore document their strategies and decision-making processes appropriately. Evidence to support work done. Two takeaways about evidence to support work done are, if it's not written down, it didn't happen, and think complaint, regulatory challenge, court. If it's not written down, it didn't happen. I can't overstress the importance of this. As a former reviewer, it was a frequent issue we came across. If there's any requirement for a look back for any reason, which includes from refreshing your memory as to what has taken place, to internal reviews, complaints, regulatory reviews and fee challenges, and there's no supporting documentation in the file, then you'll already be at a disadvantage. There should be a culture and internal process that makes the contemporaneous documentation of considerations normal practice. It's much easier to document strategy and considerations at the time decisions are made or action is taken than to complete it retrospectively, albeit the strategy or consideration may need to be revisited if the circumstances change down the line. Documentation can be by way of an email, file note, template document to be populated on insolvency software or any other reliable method. Contemporaneous documentation supports what was known when the time the decisions were made. With the best will in the world, not everything goes to plan, but a contemporaneous file note will evidence that the decision made at the time was considered based on the facts known at the time. There should be a documented protocol re timely filing of relevant documents and emails. For example, the top or last person in the email chain should file the email, and emails should be filed as the appointment progresses. There's nothing worse than having to backfile a large number of emails, and it also ensures they're on the file should someone leave the team. Think complaint, regulatory challenge, court. Would the documentation in your file support you if you encountered a complaint or regulatory challenge or court action? Good supporting documentation is the first line of defence in these circumstances, and remember they all take time and money to deal with, which is not recoverable from the case. Documentation errors were another area highlighted in the ICAS visit findings report and may in some circumstances risk the process being found to be invalid. Standard document packs may be prepared in-house or by an external provider. Either is acceptable, so long as they are kept up to date and maintained in relation to statutory, regulatory and current best practice requirements. Excuse me, we've got no dogs, but we've got lights going out. One of my recommendations would be to strongly encourage your team to resist the temptation to use a letter or document that they would have used before, and to always use a fresh letter template or document. Updates to letters and documents are not always communicated in detail to every member of the team, either by the internal team or staff member who updates the letters, or by the external provider. Taking a fresh template each time ensures that the most up-to-date version is being used. Be aware of statutory and regulatory updates and ensure documentation is updated in advance of the changes going live. One of the advantages of using an external provider is that this work is done for you. The provider will no doubt be aware of the issues being identified in visits to other firms they're engaged by and will update their document packs accordingly. Review documents frequently when signing or approving documents. It sounds obvious, but read them carefully and ensure they're accurate. Dates are all correct, and the document content is clear and suitable for the purpose it's being issued. Again, when reviewing documentation, check for general accuracy and typographical errors. If it's been drafted by someone else, it may be that they're no longer spotting the typos, etc. Also, template documentation may need to be tailored for the specific circumstances, but be careful of deleting text, as for example, there may be a statutory requirement for creditors to be provided with certain information. The ability to request the permission of a committee, for an example. Check the consistency of information across documents, dates, values, narratives. For example, in relation to proposals and progress reports, does the initial document identify and address the assets declared in the Statement of Affairs? Does the proposals or document give a clear narrative about the realisation or outcome of each asset and the work performed by the IP? Is the information consistent across each individual document and each successive report? For example, in relation to dates, values, and narrative, and do the balances carried forward to the next report or between appointments match? For example, admin to CVL conversions. If not, has an explanation been provided? What are the review processes? Is there an ability for someone who is more distanced from the document to review the draft document for accuracy and consistency? Often a fresh pair of eyes sees errors or inconsistencies more easier. I am aware that that might be easier said than done depending on the size of the firm and the nature of the appointment. Ethical considerations, always an area of focus by the regulators. And again, I can't stress enough the importance of documenting all your considerations and retaining copies in the file. In particular, the regulators are looking to confirm compliance with the revised Code of Ethics, which was effective as of the 1st of January 2020. I appreciate this is more than 2 years ago now, but you may not have had a visit in that time, and if you haven't, you should consider reviewing your processes to ensure they've been updated to reflect the changes introduced. The 5 fundamental principles remain: integrity, objectivity, professional competence and due care, confidentiality and professional behaviour. The code's in a new format whereby requirements are identified by an R and application material is identified by an A. There's a new section on the IP as an employee. Sections on obtaining specialist advice and services, agencies and referrals, referral fees, commission and inducements have all been expanded. And I'm going to pick one of these, specialist advice and services, and talk about it in a minute. There's a new section on responding to non-compliance with laws and regulations, and new examples specific to the Republic of Ireland. It's important to clearly document consideration of the Code of Ethics, including the threats and safeguards considered and applied. Consider how best to do this within your firm. It could be by way of a software product, Code of Ethics checklist, or a template. Detail any safeguards or mitigation that are in place if they're required. And remember the public interest perception and reasonable and informed third-party tests. The Code of Ethics requires that the application of safeguards, where applicable and capable of being applied, to reduce the threats to a level at which the insolvency practitioner, using a reasonable and informed third-party test, would likely conclude that the insolvency practitioner complies with the fundamental principles. And finally, ensure timely formal approval by the IP is recorded in the file and on the system. You should also have processes in place to continue to review the circumstances of the case in view of the Code of Ethics throughout the lifetime of the appointment, possibly by diary reminders to seek written confirmation that there have been no material changes in the circumstances. I said earlier I'd touch on the area of specialist advice and services and the possible self-interest threat which may arise. Processes should be in place to document where specialist advice and services have been sought, which include but aren't limited to evaluating whether or not such work or advice is wanted, what best value and service has been received for the work undertaken. The reasons for choosing a particular service provider have been documented. Why was that provider chosen? Whether the incumbent provider of that service to the company with a detailed knowledge of the business, was the requirement for the service put out to tender? Was it a specialist service area where there are only a limited number of providers with the appropriate expertise, or some other valid reason? The Code of Ethics requires that the IP shall review arrangements periodically to ensure that the best value and service continue to be obtained in relation to the insolvency appointment. Last but not least, let's have a look at the documentation of pension checks. As you'll all be aware, Section 120 notification is required to be sent to the PPF within 14 days of knowledge of any occupational scheme, whether a defined benefit or defined contribution. If a notice is sent out with this time frame, the PPF may report the delay to your RPB. Pension checks should be carried out for all case types, even if there's no notification requirement, for example, in NBLs. The reason this is important is that there may be an old pension or pension deficit, which current management are aware of, which would render an NBL insolvent. Whilst the likelihood of this is low, it's a possibility, hence why a search should be carried out. Where and how should you check for a pension? You should carry out the searches on both the PPF and government websites, remembering to search by both name and acronyms, full stops, and under former company names, and search under the company registration number. The initial directors' questionnaire should ask for confirmation in respect of any pensions. They should also carry out a review of wages and bank statements for payments to pension providers. And having carried out all of these steps, you should remember to evidence and date the work you have done in relation to the checks. I'm aware in some instances at least the PPF search carried out is not, the date of the search carried out is not shown on the search result. Please remember to add the date the search was completed to the saved document. Otherwise, the regulators may query when the search was actually performed. As I've gone through the presentation, I've mentioned a couple of relevant websites and documents, so here are the links to the information I've mentioned. And that brings me to the end of my presentation. I hope you found it helpful. Thanks for listening, and now back to Shona.